And now to anti-corruption fight. The governor of Nasarawa State, Abdullahi Sule, has urged the National Assembly to establish a special court dedicated to handling corruption cases in Nigeria. Governor Sule made the call at a passing out parade of Detective Superintendent Cadets Course 10 and Detective Inspector Course 7 of the Economic and Financial Crimes Commission, held at the Nigeria Police Mobile Force Training College, Akwanga, Nasarawa State. In his remarks, Sule noted that corruption trials in the country often drag on for too long, undermining the fight against the menace. According to him, until Nigeria addresses corruption decisively, the country will not be taken seriously on the global stage. Now, to help us put this into perspective, we're joined by legal practitioner Elvis Asia. Thank you so much for joining us, Elvis. Tell us, does the Nigerian Constitution allow for the creation of special courts outside the existing judicial hierarchy?
Thank you for having me on the program. Within the current constitutional framework of the country, the courts that are recognized are clearly specified. There's no provision that creates a special court called anti-corruption court. But however, if you look at the legal framework, it is possible for the various courts to designate, particular courts within the jurisdiction to handle corruption cases. In places like Lagos, for example, you have courts with special focus, either on probate, land matters, sexual-related offenses. So you can have that within the current legal framework. Why it is a good thing that it is coming from the governor of a state, because it's good to hear that politicians, some politicians are interested in the fight against corruption. What we need immediately is essentially investment in the judicial system that will allow a comprehensive resolution of all kinds of disputes. Yes, it is, it's not a bad idea if we have special courts designated for that purpose with, the requisite resources, personnel, and of course, training that will enable them to handle those kind of cases. You can have that within the current framework. Or if you want to have a court, different from the current system that we have, then you will have to perhaps, look at amending the legal framework, the constitution, and having a law that specifically creates such a court. But in my view, within the current legal framework, we need to fix the system. We're not putting in money into the judiciary. We're not investing in personnel. We're not investing in infrastructure. We're not investing in technology. We have so many cases, and we have few judges who are handling them. We haven't done much about the recruitment process that is largely not merit based. These are fundamental issues we need to fix to ensure that we are able to deal with corruption cases. And don't often forget that there are two sides to dispute resolution when it comes to corruption. You also need the prosecution to be able to do proper investigation, have the requisite knowledge and legal findings to be able to prosecute and have people convicted. So we don't.
Apologies for interjecting at this point in time, but I just want to know what's it going to be, basically? Would the establishment of a special anti-corruption court require constitutional amendment, or can it be done via an act of the National Assembly?
I mean, it can be either way. The Constitution recognizes that, it's possible for you to create other courts, other kinds of courts using an act of the National Assembly. But the challenge you may have is that there might be conflict in jurisdiction. So the best bet would be to actually amend the Constitution to create such a court. But the point I'm even making is that you don't necessarily need to create any additional court. Within the current system that we have, you can designate the courts to handle those kind of cases and, provide the requisite resource, personnel to do that without necessarily having to go through the whole hog of amending the Constitution or making a new legislation that would obviously, increase, budget because you need additional funds. You need to, within the current system, there was a time the Chief Justice of the Federation made a call on all the heads of the various courts to designate specific courts to handle anti-corruption cases. And I think that is something we can do. In many other African countries, in Kenya, in Uganda, they are doing that. But we need to ensure that these courts are well resourced to be able to handle these cases. But if you want a full-fledged different court, then you might have to amend the constitution. Otherwise, you're going to have conflicts in terms of if it's created by just a mere act of National Assembly, you might have conflicts in terms of jurisdiction.
Now, I hear you where you say we don't necessarily need another, designated court. But in a case where it happens, would the creation of this court affect the role of, existing anti-corruption bodies such as the EFCCs, the ICPC, and even the Code of Conduct Bureau?
It will definitely not. I mean, what simply matters is that if the court is to be created, the law will clearly stipulate the kind of cases that will go there. It could be cases under the EFCC Act and other relevant provisions. The Code of Conduct Tribunal is, specifically to look at, code of conduct for public officers, which is perhaps different from the general issue of questions about corruption, so to say. So the Code of Conduct can continue to perform its role, even though in recent times we don't get to really hear from them. I don't really know what they're doing at the moment. We don't get to see any prosecution relating to declaration of access, for example, by public officers and all of that. But other corruption cases from the EFCC, from the ICPC and other relevant provisions can be, those cases can be said to go to a particular court that is designated for that purpose. And like I said, you also need to empower the relevant agencies in terms of investigation, in terms of prosecution, because many of the cases are either stored or dismissed by the courts because of lack of preparedness by the prosecuting agencies in the country. And so it's not just enough to create the courts. You need to also look at the other side of the coin.
All right, talking about looking at the other side, I was thinking we could look at it from a possibility angle now. So if established, what measures should be implemented to ensure that the special court or the designated court does not become a political tool used to target opposition figures?
Well, that's the major concern for many people, that when you create a special court, it might become a tool for people in power to, impose their will. But I think the most important thing that can be done is to ensure that the recruitment process, recruiting judges for such a court, should be merit-based. This system that we have now, currently, does not seem to, there are so many political influences in the process. We need to take a cue from what is happening in the UK, where, recruiting judges, there's even a part where the public can make imputes in the process. You need to have a system where the judges are independent, from politicians. You need to ensure that funding for such courts are specially created, for that purpose. You need to ensure that there's transparency and accountability in the way and manner those courts are run, and all of this will be put in the relevant law and in regulations and rules of the court that will ensure that those courts function properly. I think the most important thing, like I said, is the issue of ensuring that the personnel of the court, from the judges to the registrars to all those who are using the courts, there's merit in the way and manner they are recruited, and they're not subject to political influence.
All right, thank you so much, Barrister Elvis Asia, for having this conversation with us.
Thank you for having me.